The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
You may be seated. Good afternoon. We have two cases for submission this afternoon. The first one is Homeland Energy Solutions, LLC versus Retterath. The second one is Standard Water Control Systems versus Jones. We are ready for the arguments in Homeland Energy Solutions. And Mr. Jason Miller, you're going to go first, I understand?
Yes, Your Honor. Thank you.
Thank you. Come on up.
Your Honors, my name is Jason Miller. I have the pleasure of representing Jason and Annie Retterath, who intervened in this action to enforce the operating agreement of Homeland Energy Solutions, an Iowa limited liability company that they invested in and are members of. And I'd like to start with a fact that's not in dispute in this record, and that is that the deal that's contemplated by the letter of intent, commonly referred to in this case as the MURA, is unquestionably an insider deal. This is as defined by HES's counsel in federal court before Judge Gritzner and is acknowledged by the district court in its analysis. This is a deal between the board of directors and one of its own. Under the Iowa common law, this deal can be struck down without even getting into the minutia of the operating agreement and determining what equity security may mean or what unit may mean within that agreement. Iowa's common law, as announced in 1953 or 52 and then reiterated in 53, states that deals such as this need to be viewed with great scrutiny and can be nullified on the slightest grounds. The deal here is exactly the type of deal that needs to be nullified. This is, as admitted by HES throughout the proceedings, HES did not like Steve Retterath. Steve Retterath was difficult, and Steve Retterath was somebody who they defined as toxic. As a result, they tried to push through an insider deal without allowing the members to vote, and they overpaid Mr. Retterath as part of the deal. This is exactly the type of deal that members need to know about and need to have the opportunity to approve, and that was the purpose.
Didn't Mr. Retterath start the conversation about, you said that the HES pushed it through, but didn't Mr. Retterath, wasn't he the one he'd already sold his interest in two other energy? Isn't that correct?
And Your Honor, I think that's a very good question. HES likes to focus on the actions of Mr. Retterath and fails to focus on its own actions in this case, and specifically who needs to approve this deal. So how the negotiations began and how we got to the MURA does not matter nearly as much as whether or not HES as a company did what it needed to do to obtain the necessary approval for the MURA. Who's really entering?
Am I right, though, that Mr. Retterath started the conversation?
Mr. Retterath did start the conversation, but in order to have an enforceable contract, you have to have both parties assent. And here, the party that needed to assent was the members. The members are the LLC, and they never got a chance to be apprised of or vote on the deal that ultimately is the MURA. And Your Honors, I do want to reserve time for counsel for Steve Retterath, so that's all I'm going to address right now, but I may see you in rebuttal. Thank you very much.
Thank you, Mr. Miller. May it please the court. My name is Bill Miller. I'm here on behalf of Steve Retterath. I have a couple of my colleagues, Mr. Bristlin and Mr. Feeney, with me in the courtroom as well today. Steve Retterath, Your Honors, is an Iowa kid who did well, learned some lessons on his family farm, went off, started his own business, and then had an opportunity to invest in some ethanol plants here in Iowa. And he did so with HES based on the representations in the company's operating agreement, its prospectus, and its other corporate documents. Now, he's being told that HES doesn't need to follow those rules that it laid out, and the same board of directors has taken the position that his units have been, quote, equitably acquired, leaving him without the benefits of his investment and still paying taxes on it. At the end of the day, there's nothing equitable about the treatment that HES has accorded to Mr. Retterath, and the heirs of the district court must be reversed to avoid chilling the business relationships that Iowa law is intended to govern and encourage. Now, Steve joins the arguments that Mr. Miller laid out for his clients, Mr. Jason Retterath, and so we're here instead, rather than touching on the voting issues, I wanted to focus on the arguments with respect to specific performance. I'm happy to address any of the facts in the record for your honors. I did want to touch on one area that's, I think, particularly important, which is this allegation that Mr. Retterath, my client, Steve, bribed or was a briber, or there was some sort of bribery involved. In fact, that allegation is incorrect. It was highly disputed below. And more importantly, for your purposes, and frankly, it should have been for the district court's purposes, it's also irrelevant. Even if there was some alleged bribery, that can't excuse an insider deal. That would be contrary to the operating agreement of this company. It doesn't make the units unique. Doesn't cure HES's inability to be ready, willing, and able to perform the letter of intent that, again, we've referred to as the MIRA. As this court's well aware, specific performance is a special remedy, and it requires clear, satisfactory, and convincing evidence. It's reserved only for the most unusual cases, and this is not one of them. And there's multiple ways in which this specific performance claim fails. The beginning point is that the units at issue are simply not unique. This is an element, of course, that has to be found and concluded. It's a required element, but the district court sort of just blew past that.
Wasn't what was unique was your client, and the company wanted to kind of get him out of there. That was why they were doing the deal, right? And it wasn't just to buy random units.
Well, thank you, Your Honor. I appreciate where you're coming from on that. I disagree that that was somehow made these units unique in and of themselves. And in fact, if that were even the case, or even if that was their motivation, the fact of the matter is the operating agreement provided for the mechanism for them to pursue some next stage with respect to Steve. If they felt that he needed to go, there were mechanisms there. The units themselves were not unique.
So let me ask you this. Let's assume that the contract was valid, you had proper approval by the LLC members, Mr. Retterath was paid for his shares but refused to go ahead and turn them back over, or his units, sorry, and refused to turn them over. Are you saying there's no remedy at all because LLC units are just not unique and you can never compel specific performance?
I suppose there might be a hypothetical case where they'd be unique. We don't believe it's this one.
Well, in that fact pattern, let's assume that's true. How would the LLC compel Mr. Retterath to turn over the shares if you're saying they are inherently not unique under your framework of specific performance?
Well, Your Honor, I think that the avenue that they could have pursued is within the marketplace to pursue them otherwise. There was a market for these units and a method for them to pursue the recovery of the units otherwise.
So you're saying they could never purchase the shares or force the purchase of his particular units, even if it was approved by the LLC?
Well, Your Honor, I guess I don't believe that that's right. Under the circumstances here that we have in the facts of this case, I guess if I could, I think the other elements that are also in play, of course, are relating to the remedy and then the irreparable harm that was presented by these circumstances. And there was simply no proof, again, that we had any, there was a lack of adequate remedy. The theories that had been advanced all throughout this case is that they were going to retire his units, his board powers and the like. They had that option under the operating agreement, and they could pursue to get him out of the way if they felt that that was necessary. Importantly, or a key fact, HES actually conceded that there was an adequate remedy that they had below in the district court. When the district court entered a ruling determining that the court might stay the enforcement of the MIRA, and HES pursued a bond that implicitly indicated that there could be a remedy at law surrounding the value of these shares. The fact of the matter is they sought specific performance here on the MIRA premised on an above market value. And when we look at that circumstance, the harm that is alleged is not alleged actually or as is to the entity itself. To the extent there's any harm, it would be to fellow members like Mr. Retterath, Jason Retterath. The only harm that they sought to avoid was Mr. Retterath, Steve Retterath, pursuing his enforcement of his own rights under the operating agreement. Furthermore, at the end of the day, HES also needed to be really ready, willing, and able to perform under the MIRA, and it simply was not. First off, ready, willing, and able to perform requires that the performance not breach another agreement in place. In this case, the performance under the MIRA would have breached the master loan agreement that HES had in place, which stated...
Didn't the bank officer say we were prepared to lend the money anyway to make this transaction close?
Well, yes, Your Honor.
Isn't that really between the bank and HES? I mean, if HES has proof that the bank was willing to waive the contract, why isn't that sufficient?
Well, because they actually did not waive that contract. They did not go through with that. And being ready, willing, and able to be ready, willing, and able is not adequate. They actually had to have everything lined up and be prepared to go forward. No amendment had been made to the master loan agreement. Apparently, some documents have been drafted. The steps hadn't been taken to actually perform.
But, I mean, assuming that their position is correct, that your client had repudiated the contract, at that point under contract law, they don't have to keep going. They just have to show that they would have been able to keep going if need be. Isn't that right?
Well, I don't believe it is in this context, Your Honor. I think the cases relied upon by HES for that premise are in the damages context, where there is a requirement to mitigate damages and that we have kind of a philosophy that we don't want to force a party into acting where they don't need to and might increase their damages. That's not the case in the context of specific performance.
I'm looking at Restatement Second of Contracts 363, which says specific performance or an injunction may be refused if a substantial part of the agreed exchange for the performance to be compelled is unperformed and its performance is not secured to the satisfaction of the court. So what that tells me is you would have a right to go in and argue some kind of security for, let's say, the second tranche, the $15 million that was going to be the second installment. You would have the ability to go argue that should be secured before you should have to tender your shares. But it doesn't say that they have to actually have performed in full before they can get specific performance, right?
Well, Your Honor, I'm sorry, I don't completely follow your premise on that. I think the circumstances here are actually flipped. I mean, if it had been Mr. Retterath making this claim in this situation for the second tranche, that might be one circumstance. But to get us to that point, under these facts, under where HES is saying we were ready, willing, and able, when in fact they were not, and that they could not proceed with this agreement, that doesn't make that applicable. Of course, to have, well, I'm sorry, the other aspect here too is that HES simply did not complete the conditions precedent. They didn't have the financing of the bank approvals in place. All throughout the case below, the argument was that they were going to proceed with cash on hand. They admitted that. When it came to trial and the testimony or the evidence was that they only had $5 to $6 million cash on hand, we got into this theory that they had the prospect that the bank would have permitted them to proceed. But that evidence, again, should not have been admitted, should not have been relied upon. And the fact of the matter is, again, the line of credit restricted the use of that money for repurchasing units. We also have, of course, the anticipatory repudiation argument. I think a key place to start with there is that to the extent there's an allegation there was an anticipatory repudiation, HES never acted as if there was. They proceeded, they pushed, they wanted to proceed with this case. They continued to say, we're ready, willing, and able to go ahead. Furthermore, anticipatory repudiation, we'd suggest, is simply not relevant for the specific performance context. As I noted earlier, again, the cases cited are in the damages realm. HES had to be ready, willing, and able to perform, and to the extent there was any repudiation on anyone's part, it was on their own by failing to be so. This contract, time was of the essence, and it should have been resolved. The court should have resolved this case with a finding that no specific performance should have been ordered. See, my time's running out, so I just say at the end of the day, this court really need not address the bifurcation issue that was presented. Instead, the court should reverse the district court's ruling granting motion for summary judgment that concluded that no membership vote was required, reverse the grant of specific performance, reverse the denial of affirmative defenses. I see my time is up. Thank you.
Thank you, Mr. Miller. Mr. D?
Thank you, Your Honor. May it please the court, counsel. Steve Retterath repeatedly lost argument after argument on issue after issue over the course of about 5 years of litigation in the district court in front of 5 different district court judges. That's how long this went on. In addition, he had at least 2, maybe 3 requests for interlocutory appeal to this court, which were all denied, and he tried a removal to the Southern District, which was remanded back. This appeal is the quintessential case of the kitchen sink, throw everything up against the wall to see what sticks kind of case. They have appealed almost every single issue that was raised by these and ruled on by these judges, small to large. They are effectively arguing that all 5 of these district court judges were wrong on all the issues they addressed. And you know better than anyone in this room that doesn't happen. This is a very straightforward case. It's a case of breach of contract caused by a seller's remorse, Mr. Retterath being the seller. All of his efforts in this case have been towards getting out of the MIRA so that he wouldn't have to pay the taxes, which he figured out he was going to have to pay the day after the board approved the MIRA on June 19th of 2013. He doesn't refute anywhere in the record. They never refuted, even in his testimony, that he did not want to pay the taxes. And in fact, if you recall in the record, he contacted, the day after they talked to the accountant at RSM McGladrey on June 20th, they contacted, Retterath had a conversation with fellow board member Robert Siraki, who coincidentally was his cousin's husband, and told him, I no longer like the deal because I found out what I have to pay in taxes. Siraki immediately sent an email to the board informing them of that conversation. That's what this is about. And it's important for this court to remember, too, that 6 months earlier, in December of 2012, Mr. Retterath had entered into an identical MIRA. I don't mean similar, greatly similar, an identical MIRA, the membership unit repurchase agreement, with Golden Grain Energy. Golden Grain had the same operating agreement as Homeland. It was the same contract. And also, Golden Grain had the same bankers as Homeland as well. The operating agreement is the same. There were no complaints ever made by Mr. Retterath about anything related to the Golden Grain contract. And importantly, when we asked him that under oath in the trial, we said, why aren't you making all these complaints that you're making about the Homeland contract? Why did you make these complaints with Golden Grain? That you needed a member vote, that it's not really a contract, it's an offer that he didn't accept it, on and on and on. And he said, quote, because they, Golden Grain, they paid me what I wanted. That's in Appendix Volume 6 at page 335. That's all this case is about. As a side note, I've always found it interesting in the time I've been involved in this case that we had, as Mr. Bill Miller noted, a guy who started with nothing and became a multimillionaire in the construction business in South Florida. He had so much money that in the mid-2000s he invested approximately $43 million in 3 ethanol plants, Homeland, Golden Grain, and Absolute Energy. He had so much money that when it came time, when he got scared about the ethanol business and wanted out, that he offered $5.1 million to one of his fellow board members to vote with him. But he doesn't want to pay $5.6 million in taxes.
All right, let me ask you about one of the multiple issues he raises, which strikes me as potentially having some merit. there is an order below, I guess, that you're going to get your attorney's fees too, and the provision that is being relied on does seem like an indemnification hold harmless type provision. And didn't we say in Nevada Care that that isn't enough to, in a first party situation when it's not a third party situation, to effectuate fee shifting? How do we get around, or how do we distinguish Nevada Care?
Yeah, I understand, and as you may recall, I had some familiarity, as they keep pointing out, with the Nevada Care case back at the time, and that was a holding that my side advocated for. I think what we've got here, though, Justice Mansfield, is a situation where enforcing the indemnification provision to only apply to third parties would render it completely meaningless here, because unlike in Nevada Care, there are no viable, realistic third-party claims that could be made against Homeland as a result of Retterath's breach. In Nevada Care, there were a bunch, because if you remember, it was capitation. It was a contract between Nevada Care and DHS for capitation rates that would be paid to medical providers, hospitals, doctors, clinics, and all that. And if the capitation rates were wrong, then there was the potential for claims to be made by these providers to DHS, for which DHS then required indemnification from Nevada Care. There are no viable third-party claims. And if you think about it, I do a lot of contract litigation, and you know, there's no scientific study, but a huge percentage of the contracts that I deal with that are in dispute, that have this kind of language in it, do not have viable third-party claims that could be made against one party if the other one breaches. My point is that what the court has to consider as part of the clear and unambiguous evidence of the party's intent is that sort of the default interpretation, if you will, that it only applies to third-party claims, could render the entire provision meaningless, which this court has repeatedly held, all courts have repeatedly held, is a violation of contract
But that sounds kind of like a gloss on what we said in Nevada Care. I mean, either the provision clearly covers first-party claims, or it doesn't. And this strikes me as very similar to what we had in that other case.
It is very similar to what you had in that case, Justice Mansfield. But you also had in that case a series of, there was additional evidence. There was a series of 5 contracts. They were annual contracts. And the latter 2 of those 5 contracts, the attorney's fees clause, the indemnification provision had been amended to add a specific prevailing party provision, so that the court, in your opinion, in Nevada Care, you found that's evidence within the language of the contracts that the first 3 contracts did not involve or encompass claims between the parties to the contract, because why else would they have amended? But what I'm getting at is simply it's a little bit of the paradox of the irresistible force hitting the immovable object. What do you do with that interpretation in Nevada Care when you have a contract for which there just are no third-party claims, and you're requiring the court to interpret it to apply only in that situation? You have written it out of the contract. And I would suggest that the context of the contract, the subject matter, and the parties has to be considered when you're looking at those provisions. We are in no way asking for any change or modification to the Nevada Care holding, but what needs to happen is, as I said, a consideration of the context in which each contract was entered, so that I guess primarily the district courts that are going to be making these rulings do not interpret the language to make them meaningless and just superfluous, which we all know is just violates basic principles of contract
interpretation. Why couldn't you just put an attorney fee clause in there rather than an indemnification clause, if that's what you were really trying to get at? Yeah. Instead of putting an indemnification clause, which has a different purpose than an attorney fee clause.
Right. I agree. I agree, Your Honor. If it had been the prevailing party language like we had in the last 2 Nevada Care contracts, or like we've all seen in contracts, we wouldn't be here with this. So, I don't know. I didn't draft the contract. But in this situation, there is no interpretation of that agreement other than it applies to the 2 parties, because there just are no other third-party claims. I mean, you can imagine a case where, like, a distributor. There's one. You've got a food company, a manufacturer. They've got a distributor, a local distributor. The distributor goes out and takes the food to the grocery stores and the restaurants around town. If there's a problem with the food, let's say the food spoils or something, clearly the end user is going to have a claim against the
But
manufacturer.
in this case, what happens if the bank would sue HES over the financing? And then there's a third-party claim. We don't know if that claim's ever going to be made.
Based on, oh, sorry.
Who knows what? I
Right.
mean, we can't figure every idea. So if the bank would sue over that, or some other person would sue on some claim, good or bad, the indemnity agreement would kick in.
Right, it has to be a claim based on Mr. Retterath's, in this case, on Mr. Retterath's breach of the contract, and then somebody would then, as a result of his breach, would then have a claim against Homeland for, I suppose, damages. That's what you indemnify against. And what I'm saying, Justice Wiggins, is there are no reasonable, viable such claims. I mean, we are all trained to come up with hypotheticals and situations, that might appear, but the reality is there isn't any such claim that would occur here. Based on, in fact, we've had 6.5 years since Mr. Retterath's breach, and there have been no third-party claims filed against Homeland as a result of his breach. The intervener's claim, as Mr. Miller admitted, is a claim that Homeland breached the operating agreement. It has nothing to do with the fact that Mr. Retterath breached the MIRA.
I'd like to ask you a question about the specific performance before your time runs out.
Yep.
Would you address whether HES was ready, willing, and able to perform, and maybe counter some of the comments that were made by opposing counsel?
Yes, absolutely. As the court knows, the record is replete with about 6 weeks' worth of communications between Homeland's counsel and either Mr. Retterath and Mr. Retterath's counsel, telling him that we've got the bank approvals, we're ready to go. The record is unrefuted, first of all, from the standpoint of testimony, that the bank and Homeland's people we had the bank officer testify at the trial, and we had all the bank documents. And he testified they had been approved. One of the exhibits and evidence is the loan committee's approval for this, for the funding of this. So it was ready to go, but there was going to be a loan origination fee. And of course, Mr. Retterath had spent 6 weeks telling Homeland there is no contract, there will not be a closing, the contract is void ab initio. I mean, even counsel won't admit to it as a contract. So I can't remember who asked the question before, Mr. Miller, but the fact that the repudiation had begun in the 3rd week of June, Homeland wasn't even obligated to go down the road to be ready, willing, and able to close anyway. But it did go down that road, and it was ready, and there is absolutely no evidence that the bank was not going to provide this funding. I mean, they all testified to it, the bank documents agreed to it, and interestingly and importantly, I mentioned before that Golden Grain had the same bank as Homeland. Golden Grain also, this is all on the record, Golden Grain also had to get its master loan agreement amended to allow its line of credit to buy out Mr. Retterath to repurchase his units. And in that case, and because we asked, both sides asked the witnesses all about this, the bank didn't amend the master loan agreement for Golden Grain until after Mr. Retterath had been paid. And the bank said, the officer essentially said, for good, bad, or otherwise, that's how we do things, and that's how we were going to do it here. And he said, and the fact is, we don't need to amend it if he's not going to close on this thing in the first place anyway, as he's been telling us. So it was all there. Along the other lines, some of these other conditions precedent in Section 5 of the MIRA, Homeland's counsel, again in late June, about the 3rd or 4th week of June, sent a draft mutual release agreement to Mr. Retterath and his counsel. They never responded. They never addressed it. Homeland's counsel followed up at least on 2 other occasions and said, hey, what's the status of this? Where is it? We're ready to go. We're ready to move forward. So I don't know if there was another element of the ready, willing, and able that you wanted me to address besides that.
No, but if you clarify one more thing for me on the record, I'm not quite sure, but I am assuming that the agreement for the MIRA was initiated, as I stated earlier, at the request of Mr. Retterath, correct?
Absolutely.
That's why this whole discussion started?
Absolutely. Absolutely. The conversation started in the fall of 2012 when Mr. Retterath got skittish about the entire ethanol industry. The Homeland formed the repurchase committee in late 2012. They had some conversations then that went nowhere. They had some conversations in February that went nowhere, and that was the end of it. That's when Mr. Retterath started down this path of trying to buy board members to get him what he wanted. But then in June, a guy named Ed Hatton, Mr. Retterath's buddy, contacted the repurchase committee on behalf of Mr. Retterath and said, this was on June 10th, I believe, and said he's willing to sell back his units for $1,100 a unit, which is about $28.5 million. And interestingly, the repurchase committee got back together and they accepted that offer. And they prepared the draft MIRA with those terms. They sent it to him. Mr. Retterath sent it back and said, oh, it was $1,100 a unit in 3 installments. Mr. Retterath sent it back and said, okay, I don't want installments now. I want it all in one lump sum. The repurchase committee agreed to that. Sent it back to him. Then this is when he took it and said, okay, well, that's not enough money. So he crosses out the $28 million, writes in $30 million, initials the pages, signs it. And as a side note, these are not the actions of somebody who's never dealt with a contract before. This is a guy who made his money in the construction industry in Florida. He knows how to deal with contracts, big contracts on tight timelines. And then the repurchase committee got back to him and said, okay, we're also okay with the $30 million. They kept agreeing to his request, and they said, but we need it in 2 installments, and he agreed to that, and that's where we got to the final draft. So that's probably a longer-winded answer than you were looking for, but absolutely. And he is also the one who introduced the concept of installment payments with his first offer. So my time is up, and I thank the court.
Thank you, Mr. D. Any rebuttal?
Yes, Your Honor.
Go ahead, Mr. Miller.
Jason Miller for the interveners. Your Honors, this is not a case about seller's remorse. This is a case about enforcing a company's operating agreement consistent with Iowa's common law and consistent with the intent of the General Assembly in enacting Iowa Code 489, 110, sub 5, which indicates that an operating agreement can specifically detail how you're going to approve an insider deal such as this.
Did your clients complain about that before or after Mr. Retterath Sr. said, I want out of the deal?
After, Your Honor. After. And that's an important point, though. It's because the members weren't apprised of this deal. I mean, when you look at the case law, it says everybody needs to be apprised and everybody needs to consent. My clients, like the rest of the members, didn't know this was happening because it's happening behind the scenes with a buyback committee trying to force out somebody who they don't want and push through a deal. And they don't tell the members. They don't get the consent of the people who need to consent. They want you to focus on what Mr. Retterath, Steve Retterath, did or didn't do. What we're asking you to do is take a look at what they didn't do. They didn't get the consent of the right people. The principals to the contract are the members, and they never got a chance to consent. Thank you, Your Honors.
I've got a question is about the attorney's fees, so maybe it's better for your co-counsel.
I think it is better for Mr. Bill Miller. Thank you, Your Honor.
Thank you, Your Honor. Your question.
Could you respond to their argument that if we reject a fee award here, we're rendering that indemnity provision surplusage?
Well, I don't think that's correct, Your Honor. In fact, if you follow Nevada Care, we're dealing with basically the exact same language. There would be circumstances, potential circumstances, Justice Wiggins alluded to the possibility. Mr. Retterath, if the proposed deal gone forward, would have been making representations such as the units were not encumbered. I mean, there are all sorts of possibilities for third-party claims that were possible, and we could speculate on. And in fact, the matter is if they wanted the attorney's fees shifted, they could have done so. And what Mr. D didn't mention is that it was his firm that drafted this agreement. So he may not have known exactly why they didn't do that, but his firm would. Furthermore, I was reflecting a little bit about Justice McDonald's question on specific performance. And, Your Honor, if I could take another shot at that one. I think what you're getting at was what would you do in the circumstance here? Would you ever have specific performance under these circumstances? And respectfully, I don't think so. That's probably not going to happen here where you have a marketplace for these units, and they could have been bought and sold within that marketplace that were not unique otherwise. The remedy here would have been if they were dissatisfied that the MIRA didn't proceed, go find another purchaser and pursue damages in a breach of contract claim. The fact of the matter is the units were not unique. And notably, we didn't hear anything from HES with respect to the actual elements of their specific performance claim. There was a lot more piling on Steve Retterath. So, if you don't have the facts with you, you don't have the law with you, you pound on my client, apparently. That's not appropriate. That's not what the law is, and the elements of specific performance simply were not proven. Furthermore, with respect to the ready, willing, and able aspect, everything that Mr. D or HES explained to you here just goes to the point. They simply were not ready, willing, and able to perform. Simply stating it, as HES did, or they attempted to do through counsel, well, we're ready, willing, and able to perform. Okay, well, show us. Where's the bank agreement? Where's the loan documents amendment? What have you done to actually be that way? And the responses back were, trust us. We're ready, willing, and able to perform. Now we've gone through the discovery process, through trial, and discovery has revealed, in fact, they simply were not. Skepticism and concern about ready, willing, and able to perform was well-founded.
Doesn't the discovery also show that your client was saying, I'm not going to do it, it's not going to happen?
Well, Your Honor, I mean, I guess that's a fair characterization if you want to make it, but at the end of the day, his motivations and the supposed remorse really are immaterial. These parties were possibly entering into an agreement with certain statements made. He was asking for proof that what was going to happen was legal and ready to go and binding, and was not forthcoming. So he was within his rights to ensure that he didn't get into a position where he potentially left himself exposed into further claims or other claims. And with respect to this golden grain concept, again, we hear all sorts of stuff about golden grain. Well, nothing about the golden grain scenario can change the circumstances of the HES case and the obligations that the parties had under the operating agreement. And for all those reasons, we ask you reverse the district court. Thank you.
Thank you very much, Mr. Miller. We'll consider this case submitted, and we're ready for the next oral argument, Standard Water Control Systems, Inc. versus Jones.